Good morning, how are you?
No, I'm well, thanks. How are you?
Very well, thanks. Very well.
Yes, thank you so much for logging in. Please note your hearing starts at 10:30. So now we're just going to hear um, from Northwest Cricket, and then we will. I'll give you a call to just join us once we're ready to address you.
Perfect, no problem.
Okay,
Thank you. All right.
Right, who else is online?
Up to this point. Let me, at this stage, just do a brief explanation of what I propose we should embark upon. Now, all of us are aware that at the beginning of August, we started to, was it beginning of August? Beginning of July, we started to hear a number of testimonies by a number of people from a number of cricket clubs and unions and what have you. And in the course thereof, as would have been expected, I received and heard testimonies in which certain people got mentioned, particularly to their detriment, in the sense that there were certain allegations that were made under oath or under affirmation, the nature of which gave certainly me and everybody else with whom I'm working the sense that there was a need for rebuttal of those allegations and or some engagement with the allegations, even if it didn't amount to a rebuttal, the nature of which would give a different slant to what was being said than had been said to me. So I decided, and I had thought in the fortnight from the last day we were here up to this point, people would have been able to get all the allegations that were made, certainly in affidavit or statement form, and would have been in a position today to proceed to deal with such allegations as had been made, either by themselves or through their attorneys or through their counsel. Now, there was a bit of confusion as to what really was going to happen this week, given that in the course of the fortnight during which we had adjourned, there was communication from a number of people, either through their attorneys or through their own indications to us, that they wouldn't be able to testify in rebuttal or to engage those allegations that had been made by those who have already testified up to this point. That is the reason and the purpose for today's proceedings. So that the record should show if there are people or if there is a view in relation to which I may, after hearing everybody, make a ruling that there hasn't been enough time for people to prepare to engage the allegations that were made by those who have already testified. Then, then I will hear that. If Werksmans, for instance, who are, a legal resource to the office of the Ombudsman, are able to say, well, insofar as there's an allegation that affidavits were not sent to those who were being mentioned in those affidavits timeously, or if there is Werksman say we have had problems in doing so, we also need more time, or we are able to engage the submissions that were made in writing in response to an invitation for today, and to deal with whatever oral argument would be made or oral submissions would be made in the attempt to clarify this. Now, why are we doing all of this exercise? The first reason for us, certainly for me as the Ombudsman, is that I want to be able to have people dealt with fairly. When allegations have been made, it is only too fair that people must be given an opportunity to engage them. However, as we all know from the rules of procedure that were published, from the terms of reference that were published, this project, this SJN project, Social Justice and Nation Building Project, has a lifetime that is constricted by the time that has been given to it. So in our attempt to meet the goal of having a report within a reasonable time, we must also make sure that people who have been mentioned in public, sometimes to their detriment, have had an opportunity to engage those allegations in such a way that I will have a balanced view. That for me is paramount. That for me is the fairness that I want all parties to enjoy when they are appearing before me. And that, in a sense, will cause us to write a report that is a reflection of all the views, because I've now heard a one-sided version of those allegations that were made by those who have already testified. So today, I thought that it would be proper for entities or for parties to just give me a brief indication of their state of readiness to engage whatever has been said about them, either as a union or as individuals or as whatever. And thereafter, I will have to make a determination as to what happens during the rest of the week. I am advised that there are others who, notwithstanding the allegations that were made, are ready to make their presentations, and to meet the allegations that have been made against them. Now, I've got here in front of me a schedule of what should happen today. And I am sorry that, we have eaten about 25 minutes of the 30 minutes that was allocated to Northwest Cricket Union, represented by VDD Inc. attorneys, who I would hope would use the half an hour, to accommodate what I have outlined today to be the purpose of us meeting here. I believe VDD Inc. is on the line, and I need to know whether whom I see on the screen is the director in VDD Inc., Mr. Van Devender.
Chairperson, thanks a lot for the opportunity. I'm Frick van Deventer, Director of Van Deventer Dlamini Incorporated, instructed by the Northwest Cricket Union.
Yes.
Can I proceed?
Yes, please.
Thanks for the great opportunity. I want to thank you also for your hard work. During the social justice and nation building hearings, some adverse submissions were made against my client, the Northwest Cricket Union, and certain individuals. We have been instructed to assist our client to prepare and submit a written response to the Transformation Ombudsman in reply to these submissions. Northwest Cricket, in turn, is represented by H.P. Prinsloo, the current Chief Executive Officer, who has been appointed on the 1st of November 2018. I'll try to be brief, Chairperson.
Yes.
Our client was required to finalise and submit its written reply on or before the 18th of August 2021. I'm addressing the Ombudsman today because despite working diligently, weekends included, we were not able to finalise the written submissions as required. The time afforded to have done so was unfortunately not reasonable and adequate. I confirm that our company, Van Deventer Dlamini, addressed letters to the Office of the Ombudsman on the 16th and the 17th of August, respectively, in this regard. Formal written submissions on request for an extension of time followed on the 19th of August. I wish to draw your attention to the following and request your consideration to our client's right and interest in having a fair and reasonable opportunity to participate in the SJN hearings. The main reasons we were unable to finalize the submissions are: since receiving the complete record, our client effectively had 5 calendar days, of which 3 were business days, to consider, consult, prepare and submit a reply on record of these proceedings in excess of 180 pages. We only been provided with the transcribed record of the evidence of Dr. Opanuka Gisang, given to the SJN hearing on the 11th of August 2021. It did not include the written submissions and the annexes to his evidence. After the request was submitted, those written submissions and annexes were provided to us on the 12th of August. The transcribed evidence of Dr. Opanuka Gisang consisted of 78 pages. The written submissions are 30 pages and the annexes were 32 pages. We were informed that Mr. Mchabi and Mr. Papi Mbesi also gave oral evidence on day 19, and we subsequently requested a copy of the transcribed evidence. The transcribed records of the evidence were only provided to us on the 12th of August, that Thursday, at 12:25 p.m. These transcribed records consist of a further 64 pages. Our client considered the submissions and have established that certain submissions are unfounded and factually incorrect. Considering the far-reaching consequences, it cannot be left unattended or unanswered or on any level. The submissions contained reference to occurrences and events dating as far back as 2012. Various individuals who had either resigned, left, or had left the management needed to be contacted in order to set up consultations, to confirm the facts, to get the right versions, and during which consultations, the accusations leveled against our client and background data had to be explained to these individuals. This is a time-consuming exercise, but nevertheless, Chairperson, we, together with our client, are working around the clock as from the 13th of August to prepare a written reply, bearing in mind the terms of reference, the rules, and the purpose for which the SJN was created. I need to pause at this point to remind these proceedings that the Cricket South Africa intervened in the affairs of our client, and our client was placed under administration in 5th December 2018, and an administrator was appointed also on the 5th of December 2018. And Mr. H.P. Prinsloo and our client is required to verify all the allegations, corroborating documentations with the relevant individuals who held their respective positions during the period. The CEO, the current CEO, was only appointed in the latter part of 2018. He was appointed on the 1st of November 2018. We point out that the time afforded to our client to prepare its response are indeed very short and unfortunately unreasonable in the prevailing circumstances, as all individuals involved also have their own daily obligations. In the premises, we therefore request an indulgence, please, till this Friday, the 27th of August, 2021, for the filing and finalization of our written submissions, which request we believe is reasonable in circumstances and which only equates to 10 working days. We confirm our client's best endeavors to give its full and urgent cooperation in this process. Thank you, Chairperson.
Thank you, Mr. Van Devender. You say you request an indulgence to finalize by what date?
Friday, the 27th.
Okay. And have you received so far all the documentation that was relied upon by the evidence leaders in leading the evidence of all those people who mentioned your cricket union or your client in a manner that calls for your client to respond?
Yes, Chairperson, we get a quick response.
Right. Do you want to engage in?
Not at this stage,
Yeah. Well, do you have any comments to make as evidence, leader?
No, sir. No issues on our part. I think that Mr. Venter does acknowledge that we've given every document that was used before as evidence before you, Chair. And I think that there are no outstandings on our part, and we've got no issues with his request. You are in your hands, Chair.
Did you hear Mr. Abrams? This is Mr. Abrams from Werksmans.
Werksmans.
And they act as my legal resource. Whenever I've got difficult questions to legal implications, I run to them and I say, hey man, these guys van Deventer are putting me in a spot. How do I do this? So, and he has been assisting also, leading evidence and making sure that firms like yours do get, treated in a manner that would put you in a position to engage the Office of the Transformation Ombudsman in the way in which we have pleaded we should accommodate you. I think we have made a reasonable proposition, Mr. Van Deventer, and we just have to make sure that no one is treated unfairly. And I think, given the the volume of the work that you have had to consider, the evidence and everything else, it's not unreasonable for you to request indulgence to finalize and submit your written submissions in rebuttal by the 27th of August. In the circumstances, your submission for an extension of time is granted.
Thanks a lot.
Yeah.
Much appreciated.
Thank you very
Thanks
much.
for your little team and
Okay, no, it's all right. Yes. You are excused, Mr. Van Deventer.
thanks a lot. All of the best for the rest of the day.
Yes, we live in hope. We are always optimistic. Okay, now we should make arrangements to hear Mr. Johan van Heerden.
Hello, Mr. Chair.
Yes, hello, Mr. van Heerden.
Johan van Heerden, yeah.
Yeah.
I don't know what was the arrangement, if I was privy to the previous discussion, but I was unfortunate, so I don't know if I was in the wrong, but I thought that as soon as that finished, I will go on. So apologies if I have not adhered to protocols.
No, it's okay. The only thing I don't know, your image keeps on being impacted upon by a green branch. Yeah, there you are. Now you are.
There we are.
Yeah.
Yeah, I must admit, Mr. Chair, I'm not exactly sure how the guys have done it, but it's an image that comes up when we do our presentations. So how it came on there, I don't know, but I'm going to sit quite quiet now, not move, and maybe it will stay away.
Yes, that would be best. Let me just explain the purpose for which we have met today. And that is, there's the green. Well,
I know. I apologize, but I don't know how it happens.
well,
So apologies.
can you come back?
I don't know how. The chair.
One of the technicians is going to tell you what you need to do. Yeah, but he doesn't see you. He doesn't see your hands.
Yeah. I see it myself, but it's the first time I see it, so I apologize. I don't know how I must get away with it, so
Brian.
please,
Brian,
apology.
can you talk to Mr. Van?
Mr. Van Heerden,
Yes?
if you go to the bottom of the email on the left,
Yeah. Mr. Van Heerden, you are
Yes, Mr. Chair.
representing the Free State Cricket Union.
I am indeed.
Yes.
And it's cold. It's there was probably the most severe winter we've had in a long time. We also require that. So we've had days here from -7 to maximum of 7. So we had a proper winter.
Yeah, okay. I know the Free State, it can be cold when it decides to be
No,
so.
it is.
Now, look, I am happy to be told that in spite of the time that you got to know that you need to appear before us and deal with the allegations that may have been made about your clients. You worked, it must have been, you spent sleepless nights in making a submission,
Indeed.
and that, in spite of the fact that at some stage you may have wanted to apply for an extension, I have now been shown a statement that comes from.
My apologies, Chair. So this is the Free State Cricket Union's initial request for an extension. However, they have since submitted all their affidavits, and Mr. Johan has confirmed that he will no longer be needing a further extension, and he will be appearing before you on Friday morning.
Oh, okay. I don't know if you heard Advocate Ntsebeza.
I have indeed.
Okay, so do you confirm that you have arranged with her and all relevant people that now that you have done the sterling work you did in trying to be compliant with what I asked the parties to do, you are now ready to be scheduled for a hearing on Friday, this coming Friday?
Correct. 10 o'clock.
At 10 o'clock, okay.
Yes, Mr. Chair.
And then I think that's as far as we must detain Mr. Van Heerden. Mr. Van Heerden, it only leaves me to thank you for having moved heaven and earth and try and be compliant, because I think at the end of the day, the Office of the Transformation Ombudsman just wants to, one, to be fair to all the parties, but also to keep an eye on the timeline, because, you know, cricket is about cricket. It's about playing cricket. It's not about all the other inquiries that are that unfortunately are now taking place in order for us to have this sporting code, beautiful sporting code, continue to be played by everybody in our country without there being any suspicions that something untoward is happening. And I think your submissions from your clients will assist us when we schedule you for Friday, this coming Friday.
Thank you very much.
In the circumstances, yeah.
Just a question to the advocate. Will I receive a new ID code and things to link on Friday?
Yes, Mr. Van Heerden, we will send a new link for you for Friday.
Thank you very much. Thank you. Speak to you guys Friday. Thank you.
Thank you, Mr. Van Heerden. Well, that concludes the proceedings today with respect to arrangements that we are now confirming. You are excused, Mr. Van Heerden, and we will then engage you on Friday.
Thank you very much, Mr. Chair.
Thank you. Well, we are within time. The Titans. At 11. Oh, well, we still have got 10 minutes.
He's not online yet.
Is he online?
Brian, are they online?
Titans around Joburg, do you know? Pretoria. Yeah.
Okay. Is that? Oh yeah, they're online.
Good morning, Chairperson. Good morning, ladies and gentlemen. My name is Neil de Preer. I appear on behalf of Professor J. Fall, Pierre Hubert, Mr. Cabello Cos on behalf of Northern Cricket Union, and Mr. A.B. de Villiers. With me in the room is my instructing attorney, Professor Rian Kluter.
Yeah, wow. You have got clients who have got pedigrees, professors, yes. And you, senior counsel, so I'm in the presence of very much elevated personalities.
I have a problem with the sound. If you would give me just a sec, see without the problem lies with me.
I hear you very loudly and clearly.
Yes, I have a problem hearing you. That
IT?
I think there we are. You're on line. Thank you very much. I apologize for the
No,
inconvenience.
not at all. I arranged, Advocate Dupree, for parties to make representations to me after it became clear to me that after a fortnight of having laid off hearings, that time didn't seem to be enough for people who had been mentioned, particularly mentioned to their detriment, to fairly meet the allegations that were made by them. And in the course of certainly last week, I received various indications that there were a number of people and or legal representatives representing those people who were desirous of an extension of time, A, within which one to make submissions in rebuttal, and B, because I have determined that over and above whatever submissions would have been made by the parties, it is important for everybody that there is a record of the entire SJN project proceedings, and therefore that the people would have to appear before me today to make representations on the record as to their desire to get extensions, to indicate to me the problems that they have had in being ready to go on with the hearings as projected or had been planned for today. So I've already had one or two, in fact, two unions from the Northwest and from the Free State, and I am now giving this opportunity to the representatives, you, Mr. Dupree. As I understand, you represent the Titans as well as Dr. Fowl. And
That's correct.
And I'm not sure whether your clients have been able to prepare a written submission and send it to us, and whether, and if that is so, whether you want to speak to that or whether you want to arrange for an extension of time. Oh, I see Advocate Mnale has just given me a submission with regards to an extension of time within which your client would like to make a response, your clients would like to make a response, and that comes from Kluti attorneys, Dr. Ryan Kluti attorneys. Just tell me what you want, Council.
Thank you, Mr. Chairman. Mr. Chairman, the problem is that I do not only represent Professor Fowle and the Northern Cricket Union, but also Mr. Pierre Hubert and Mr. A.B. de Villiers.
Oh, I see. Yes, I see that.
According to newspaper reports, they were mentioned during the testimony before you, but they haven't received any notice yet of any allegation against them. So we don't know what to do, whether there will be any adverse findings against them, whether they are required to make a representation or whatever. In anticipation of the, and I must say, to assist you in your work, Mr. Kluter, or Dr. Kluter, requested transcriptions to go through. But up to this day, none of my clients had received any formal notice of any allegation against them. Professor Fowle did receive 4 emails to which there were certain annexes appended. But Mr. Chairman, he did not receive any formal notice of what the allegations against him is. If one has regard to the terms of reference in clause 2.2, and I don't want to go through it, you will be fine with it, but he must at least get notice of the allegations against any of my clients. They must get notice. And what transpired was they received an email stating that your name was mentioned, and appended to that email is either transcription or a written submission or an affidavit. There is no clear enunciation what the specific allegation is. Now, we can guess what that entails. We can go through the papers and try to determine what the allegation against each individual is. But, Mr. Chairman, that is not a fair and open process. You can only, as I understand the rules of natural justice, and Cora Hoekster in work administrative law in South Africa deals with that aspect, and specifically Section 3.2 of PAJA, and that beyond its reference to the nature and purpose of the proposed administrative action, and that is the notice, Section 3.2b1 makes no attempt to define the meaning of adequate notice. However, adequacy seems to imply sufficient information to enable a person to exercise his or her rights. For instance, at common law, the subject of disciplinary hearings is entitled to have a charge clearly formulated with sufficient particularity in such a manner as will leave him, her under no misapprehension as to the specific act or conduct to be investigated. It is also clear at common law that notice must be sufficient not only in terms of information it contains, but also in terms of the time it allows, since a party who has not been notified timelessly of the intended action may not be able to prepare his or her case adequately. And then on page 333 at the bottom, as far as information about the proposed action is concerned, it seems clear that its nature and purpose must be described with sufficient particularity, or the right to make representations will be illusory rather than real. Now, as I said, in anticipation of and to expedite our work, the Dr. Kluter requested copies of the relevant witnesses' testimonies in emails dated 13, 16, and 18 August 2021. Mr. Chairperson, you will find that in paragraph 7 of our submissions. But we did not receive any notice as contemplated in the statement made on the 5th of August 2021. And absent the contemplated notice, my clients can only guess what the allegations is, specifically as far as Professor Faal is concerned. If you have regard to the testimony that before you, there are reference to a contract with Mr. Graham Smith. Now, that's a monetary matter. It does not pertain to racism or discrimination or whatever. But we are in the dark. We don't know whether we should address those aspects, even though it does not fall within your mandate, because there was an adverse allegation against Professor Faal. And therefore, we submit, and I put it on record, that once we receive proper notice stating exactly what the adverse allegation is with sufficient detail to respond thereto, we will furnish a response to that allegation timeously and expeditiously. But it cannot be expected of my clients to guess what the allegations are. What is concerning, Mr. Chairperson, is the fact that the evidence leaders furnished us with a response earlier this morning, well, at 10 to 12 this morning, in which they say that it is not their job to give us a clear statement. We should, they do not have to do our work. We should go through the relevant transcripts and affidavits, and we should, from that, deduct what allegations we have to address. But that's not a fair and open process. And in any event, we received some of the transcriptions only on the 18th of August. That is impossible to meaningfully respond to any of those allegations in that transcription. What is important, as Chairperson, is the fact that the evidence leaders in their response does not deny the contents of the emails as we enunciated same in paragraph 10 of our submission. If I might take it, it's on page 4 of our submission. We say, for the sake of completeness, it is worth mentioning that Professor Faal received the following correspondence from Sandile Tom of Bergsman's attorneys. An email dated 4 August 2010, which was only addressed to Professor Faal, at the subject CSA SJN Hearings, Volume 1, 5 July 2021, and then a reference number, and read, the above matter refers, please see the attached transcript wherein your name is mentioned by Dr. Kula. And then, Chairperson, the attachment comprised 176 pages. They do not deny this email, but they say that we should go through 176 pages and decide which averments pertain to us. On page 5 of our submissions, we have an email dated 10 August, which was not only addressed to Professor Faal, but also to other persons, had the subject signed affidavit by Mr. Amfile Ramela, and read, Please see attached signed affidavit by Mr. Ramela for your attention. You would recall that I sent to you an unsigned version of his affidavit, which had some drafting notes. Kindly have regard to this copy as it is complete. So on the 10th of August, we get a complete copy, but it does not, there's no information as to the specific allegations or averments that we have to respond to. Then again, on 10 August 2021, an email addressed to Professor Fowl had the subject matter signed affidavit by Effie Mbaslati, read, please see the attached signed and commissioned affidavit by Mr. Mbaslati for your attention. And had 4 attachments with respective headings. Now we submit that these emails do not pass muster as a notice required to inform a person who has been adversely mentioned at the Commission. It does not notify any of the clients of any adverse allegation against him, merely says your name were mentioned. And even if it is regarded as such a notice, it lacks any or sufficient particularity to enable my clients to know whether there are any adverse allegations. And it cannot be expected of the clients to trawl through the attachments and to speculate which allegations pertain to them. They frankly did not receive notice as contemplated in Rule 5.4 of the Rules of the Commission, and they really do not know which allegations to respond to. I must say, Chairperson, I'm perturbed by the response of the evidence leaders attacking my instructing attorney, accusing of trying to waste time. But if one has regard to his conduct by requesting the transcripts, that cannot hold water. Chairperson, the allegations, as some of them were reported in the press, are serious and may have huge implications on my clients. If they do not know which allegations to address, and if they are not afforded a proper opportunity to address same and to gather the necessary evidence, some of these events happened more than 14 years ago, then they will be severely prejudiced. As Edward Murrow, the famous American journalist, said, we must remember always that accusation is not proof, and that conviction depends upon evidence and due process of law. And until now, we submit that my clients did not enjoy due process of law, especially because they did not receive the necessary notification. If we receive the notification, Mr. Chairperson, I give you the undertaking that we will furnish the written submissions within 10 days after receipt of those notices. We are not here to delay, we are not here to waste time. We want to assist you, as my clients have indicated in the submission to you with your commission, that they subscribe to the principles laid down in the Constitution, the values of Cricket South Africa, and they recognize, appreciate, and support your appointment, the SJN project and hearings to contribute to truth, healing, and reconciliation in the game of cricket. Therefore, we ask for proper notice upon which we will submit our written submissions within 10 days. The clients also indicated that they are prepared to give oral evidence after they furnished the written submissions, should you require so. I don't know whether there's anything else you would like me to address you on.
Not at this moment. Perhaps I must find out from Mr. Abrams, from the evidence leaders from Werksmans, as to whether he wants to engage your submissions today in light of what you have just said, particularly with regard to the notice.
Yes. Chairperson, I can say that the evidence leaders consider the notices as I've referred to as sufficient notice. They say it's not necessary to give any further notice, and the terms of reference and the rules do not prescribe a specific form in which the notices must be given. But although there's no form, Mr. Chairman, the notices must at least comply with the rules of natural justice, stating the with specifics and particularity the allegations against the client to enable them to answer thereto. May I quickly take instruction? We therefore request an extension of time to file our written submissions by means of a written affidavit. And I'll give you the undertaking that same will be delivered or furnished to you within 10 days after receipt of the written notice.
Yes,
Chairperson, thank you very much for the opportunity. Advocate Dupre, I'd like to respond to your submission. And I do so with absolute humility and respect. I do not think that before the ombuds here, it would assist the process if we got involved in any mudslinging at all. And I believe that we as professionals have got a code of conduct we need to comply with, and a certain level of decorum is expected of us. So I do respond in that mode. I do not intend taking up issues with you personally. I just want to address the issues you have raised. And so if you could allow me to do so, Chairperson, I'd be grateful. But before I respond, Advocate Dupre, I just want to ask questions of clarifications. I think at the outset, you said that you only Professor Dr. Fowl has been communicated with, and you have not received affidavits in which Mr. Pierre Joubert Kabelo Kasa and A.B. de Villiers are adversely mentioned. I just want to correct that for the record so that it is plain. Is that the case?
What I'm saying is that they, Mr. Pierre Joubert and Mr. A.B. de Villiers, did not receive notice. No notice whatsoever. That's what I'm saying.
Not the affidavits, you're talking notice.
No notice.
Okay, that's fine.
As required by Rule 5.4.
Let's address that, Dr. Advocate Dupre, rather. I understand the nub of your contention to be that your clients have not received notice as you regard it. In other words, you seem to be saying that the emails we sent you together with the statements or affidavits that were made by parties who appeared before the Ombudsman, as well as transcripts recording the oral evidence, are not sufficient notice. That's what I hear you to be saying. As I start my response, I really want to refer you to the rules of procedure drafted by the Ombudsman, in particular 6.4 thereof. It says, if any allegation is made against a person or organization in a private hearing, the Ombudsman will notify such implicated party of the allegation and a person or organization will in turn have an opportunity to respond to the allegation by way of affidavit or private bilateral hearing. If you look at provisions prior to that, persons against whom 6.1, Advocate Dupré, persons against whom written allegations or complaints are made will be afforded an opportunity to respond to such allegations or complaints. They may do so by way of affidavit or oral evidence. Our reading of that provision does not prescribe how that notice should be given. Sufficient, in our view, is that a party against whom adverse allegations are made should be notified. Now, obviously, in this day and age, what we would ordinarily do would be to make copies of affidavits and statements and a record of the transcript and actually hand deliver it at your client's offices or the attorney's office where there is one on record. All we did in the circumstances was to use emails as a mode of transmitting the statements, affidavits, as well as transcripts. May I also say that I think that certainly at the beginning, my colleague, Mr. Tom, communicated with Dr. Fowle personally at the time because Dr. Klute was not on record yet. And there's a lot of affidavits and statements that were given to him. As soon as Dr. Klute was on record, we communicated with him. And I think that our response clearly shows the chronology of interaction that happened between, on paragraph 8, I think, of our submissions. You see the chronology of interactions that happened today. And I think just for the record, so that we clarify it, I don't intend taking too much time of the Ombudsman. Just to go there so that we set the record straight. The chronology of interactions is as follows. I'm reading paragraph 8 of our submission. On the 4th of August, Mr. Sandile Tom sends an email to Dr. Fowle attaching Mr. Umpile and Mposwela's affidavits. Now, we use our best endeavors to make sure that as soon as a person has given oral testimony, we send the affidavits instantly. That was on the 4th of August. On the same day, we also sent to Dr. Fowle again an email attaching Mr. More's submission. On the 4th of August, again, Mr. Tom sends to Dr. Fowle again, attaching a transcript recording Dr. Eugenia Skula's evidence before the Independent Transformation Ombudsman. Now, I also need to make it clear that it's not always easy to anticipate what a person giving oral evidence is going to say. We insist on affidavits and statements before they come here, but some would say, no, I just want to speak off the cuff. And obviously, it is difficult to anticipate what they'll say. What we do in those circumstances is that as soon as a transcript is available, we make it available to you. We are not responsible for recording and transcription of oral evidence. There's an independent third-party service provider who does that. As soon as we receive it, we make it available to anybody who has been adversely affected. And I believe that sitting here today, we cannot be faulted for not doing so timeously or at all. So if you look at all these affidavits, and I'm not going to go through all of them, one way or the other, they would adversely implicate Dr. Fowle, Pierre Joubert, Kabelo Khas, and Mr. A.B. de Villiers. Now, what then is the issue seems to be that the fact that we did not give you or your clients proper notice, as you say, Advocate Dupré, according to PAJA. You mentioned section 3.2 of PAJA. This is the first time I must place on record that we have had an issue like this. Everybody else who has participated in these proceedings has been satisfied with being given affidavits and statements as soon as they're available, and also being given transcript records. To the extent that you felt that Dr. Kluter was being attacked in our response, it was not our intention, and we apologize without reservation. But the point remains. That is exactly what lawyers are engaged for. They, on behalf of their clients, will have to go through every document that has been made available, because if we were, for instance, go through a statement or an affidavit or even a transcript and say, go to paragraph A, B, C, and D. This is where allegations are made against your client. You could well miss certain things, and then we're going to get into trouble. Prudence, I believe, dictates that you, as an attorney or a counsel, you go through that. You may well even pick up things that we would not be able to pick up. I think that serves the interests of your client best that way. So at the end of the day, the issue seems to be, we hear you to be saying, give us proper notice, and thereafter we undertake before the Ombudsman that within 10 days thereof, we will then give our response. For starters, it's almost being so presumptuous that you assume that the Ombudsman will even give you 10 days to start with. You write the script, as it were, as to what constitutes reasonable period. With respect, I think that that's presumptuous. With respect, I do say that I believe it's presumptuous. And I don't think that is going to assist us to be haggling about what constitutes notice and what doesn't. I believe that every one of us must get engaged in this process in the spirit of cooperation and assisting the Ombudsman. I honestly do not see anything wrong with sending you affidavits, statements, and transcripts as soon as they're available to say, we believe on this particular date your client was adversely mentioned. And therefore, please go through this record carefully to see what allegations were made against the client. I honestly believe it is not unreasonable. But I may have my say, we may have our say, you have your say. At the end of the day, it's upon the Ombudsman to make a ruling. I just want to say that it would help this process a great deal if all of us engaged in that spirit of cooperation and assisting the process. And with respect, I believe that the attitude that you take does not assist the process at all. You even say that in your submission, it doesn't pass muster in regard to the requirements of PAJA. You don't even make an effort to say this is what you would expect the notice to look like in order for it to pass muster in your eyes. That does not help the process, and it only delays the proceedings. And we've got very limited and restricted time. And so I would personally appeal, for what it's worth, that let us cooperate and just make sure that if there's anything that is outstanding by way of statements and affidavits or transcripts that we ought to have given you, that we've not given you, let us know. My colleague is actually here, has just walked in now. And we will make sure that before long, even before close of business today, we've given you everything that you need to be given. So my submission, Mr. Chairman, is that I hear the issue about notice, and I believe that should not detain us. And I think at the end of the day, it's something that you'd have to make a ruling on as to whether we as evidence leaders were remiss in the manner in which we communicated to Advocate Dupré, Dr. Kluter, and their clients, and that we have not given them sufficient information to respond, and therefore we're prejudicing their client, and we are really seriously harming their rights. That's my submission, Mr. Chairperson.
Anything in reply, Mr. Dupree?
Thank you, Chairperson. Chairperson, if one has regard to the chronology as enunciated by the evidence leaders in paragraph 8, he did not take you to each and every paragraph, but what is interesting, if you have regard to paragraph 8.1, on 4 August, Mr. Zandile Tom sent an email to Dr. Fowl attaching Mrs. Umfile Ramela and Mpusewela's affidavits. 8.2, on 4 August 2021 at 13:02, Mr. Zandile Tom sent another email to Dr. Fowl attaching Mr. Maru's submission, not affidavit, not transcript, submission. On 5 August 2021, that's paragraph 8.4, Dr. Fowl sent an email to Mr. Zandile Tom noting that Mr. Maru's affidavit differed from his oral evidence before the SJN hearing. Mr. Zandile Tom responded on the same day at 18:55, confirming the correctness of Dr. Fowl's observation and undertaking to furnish him with the transcript relating to Dr. Maru's oral evidence as soon as he received it. And then the affidavit was, you will find, was only sent in paragraph 8.11. And that was on 13 August 2021. He sent him another email informing him that he would send transcripts relating to Sister Moreau and Sinetemba Njekula as soon as he had received them. That's on the 13th of August. So what could you do? You did not have correct or an affidavit, only a written submission. Then you receive a transcript that differs from the written submission, and you receive only the transcript on the 13th of August, and you have to reply by the 18th or the 19th of August. That's not sufficient time to address the issue. Chairperson, there is no specific form, but compliance with natural justice indicates that there must be sufficient information to assist the person to establish what the charges against him is or the allegations against him is. And by merely forwarding the transcript and the or the affidavit, certainly those actions do not pass muster. And we are not obstructive. We want to cooperate. We want to assist you. We want to help you to get to the root of the allegations, and we want to respond thereto. But as I've indicated in my opening address, as far as Dr. Fowl is concerned, there are allegations regarding contractual matters, etc., that they do not fall within your mandate. Now, we don't know whether we have to respond thereto. You cannot, the evidence leader cannot expect of us to guess whether we have to respond thereto. If we respond thereto and it falls outside your mandate, it's work that we've done which are not necessary. And therefore, we don't want to be prescriptive. If you say that we must answer in a shorter time than 10 days, we will endeavor to do that. But what I'm saying is that if we get proper notice indicating to which allegations we should respond or which allegations may implicate my clients, then we will answer within 10 days. If you say we must do it in 5 days, we'll do that. But that will assist you because you will have the written submissions of my clients, and the evidence leader can prepare on that. So we submit an extension of, we request you, Mr. or Chairperson, for an extension of time to be in a position to properly respond to the allegations against the persons mentioned once the proper notices are received.
Thank you, Advocate Dupree. I'm not going to make a ruling here now. And the only ruling I'm going to make is that the parties, that is Werksmans and the attorneys assisted by you, Advocate Dupree, should get around the issue of what the parties or what the parties you represent, Advocate Dupree, regard as a proper notice. Because it seems to me that is where the nub is. There is a view that the notice is not a proper notice. And, but you are very strong also in saying, or the evidence leaders believe that the notice is appropriate in the sense that it contains, you know, what you would need for purposes of understanding what it is that your clients must respond to in rebuttal. Now, I am avoiding making a ruling now because I think it may well be that the parties can talk to each other and see in what ways it appears that they have been talking past each other in clarifying this whole question of the notice. So I hear the submissions from both sides, but I also hear the submission from both sides to say we want to get on with the job of assisting the Office of the Transformation Ombudsman to do the work that it has been mandated by both the terms of reference and the rules of procedure to achieve. So what I am ordering now is for the parties outside of this process to get together, put their heads together, and get in the spirit in which I think both parties are committing themselves, you know, of getting to the nub of it and clarifying whether some of the issues that have been mentioned in the statements fall within the terms of reference. You have mentioned, for instance, that some of the things are contractual. But I think time that has been arranged between the parties at which they come to terms with what would be constituting adequate notice, why it is adequate notice, without having to rely on the form, just the substance. When once the parties have been able to engage each other and take out, you know, what complies with the expectations of everybody to constitute what is expected of the parties that have been mentioned to their detriment to do in order to rebut the allegations or to engage with them. When once the parties have come to a clear understanding, then the process of submitting and coming to speak on those allegations or on those submissions will have been achieved. So what I'm asking now is that the parties must take time and they must indicate, you know, to me in the course of this week whether they have been able to come to an agreement as to what constitutes the notice and as to whether, in fact, the clients whom you represent, Advocate Dupree, are now clearly understanding which items they ought to deal with by way of a rebuttal. So what I'm saying is I reserve my judgment or my view or my ruling on the issue that you have raised. But I just need to remark that I'm impressed by the fact that all the parties, both the evidence leaders and yourself, are committing yourselves to assisting this process we are operating under strictures of time. And unfortunately, we don't have forever. But whilst we don't have forever, it doesn't mean that rights must be, rights that, you know, the litigant parties have at law must be ignored. But I'm so very confident and optimistic that good men and women putting their heads together on what the nub of the issue is, you as well as Werksmans will be able to present to me your representation as to what your clients' responses are to the allegations that were made against them. But it will now be in circumstances where everybody, and especially the Office of the Transformation Ombudsman, will have been assisted by parties having, outside of these formal proceedings, clarified to each other exactly what it is that they consider is necessary for us to make progress in this regard. If, however, the parties are not able to come to an agreement, which would be extremely unfortunate from my point of view, then I would have to do what I have to do. But I stand down this matter to a time when, after the parties outside of these proceedings have clarified to each other what it is that needs to be before me, for me to be satisfied that a proper notice was given and a response thereto was made. Until that has happened, the matter is stood down.
Thank you, Chairperson.
Yeah.
May we log off?
You are excused, Advocate.
Thank you very much, Chairperson. Enjoy your day.
Okay. Same with you. Now, good day. Yeah, it's close to 12. Good day, Dr. Titi. Can you hear me?
Yes, I can hear you, Chair.
How do we pronounce your name, your surname? Is it Titi or Titi?
Titi.
Titi.
Yes.
Titi.
Yes, Titi.
Titi. Oh, yeah. Hi, man, huh? Why am I not comfortable with that? Titi. It's like it's an, you know, an Englishman's pronunciation of. Okay, Dr. Titi. I would imagine that you are aware of why I have requested the parties to appear before me today for purposes of making representations. And the representations are of a nature that are seeking to give a fair opportunity to those who represent people who were mentioned ostensibly to their detriment in the course of the testimony of those who have appeared before me up to this point. The purpose, the aim is to ensure that nobody is dealt with unfairly because certain things were said and they remained unresponded to. A response might either be to say there is a nuance to what was said to you, Mr. Transformation Ombudsman, which, if it were left undealt with, then it would leave a wrong impression. And that is why we take the opportunity to come and either rebut totally what has been said, or to say it has nothing to do with you in your project, or to say if they had understood what they testified about before you in the way in which I am responding to those allegations, then you would find that they actually were backing up the wrong tree. That's the one version, or that's the one purpose for today's proceedings, is to hear parties who seek to make representations. If they have made representations in writing already, that's okay. If they say, look, we would like more time to engage all the allegations that have been made about us or about our clients, and therefore to reduce that to a written submission, and at an appointed date to come and speak to our submission, either in rebuttal or in explanation. That simplified is the purpose of today. I see there is a document from Tabak before me.
That was yes, it was sent to your office on the 19th, Mr. Chairperson.
Yes.
The essence of the document, Mr. Chairperson,
Yes.
is to seek an extension until the 6th of September.
Yes.
So that Tabak's, come again, Chairperson?
No, I'm listening.
Yes, to seek an extension up until the 6th of September, so that Tabaks can seriously consider the allegation that has been made against it, and formulate a position whether to respond to them in the form of an affidavit or to make a written representation on those allegations that have been made. We set out the reason for the request for postponement. You will see that on paragraph 8 to 8.4 of the letter that was sent to your office on Friday, the 19th of August, Mr. Chairperson.
Yes.
Yes.
But are you, it's just a question I'm asking.
Yes.
Are you aware of the strictures of time under which the Social Justice and Nation Building Project operates? There is a perceived date by which the office of the Transformation Ombudsman must have not only completed its work, but also must have written a report which it should submit. So that...
No, we are very much aware that you operate under a strict time frame, Mr. Chairperson. So the 6th of September is just a suggestion from our side And unless you have a different view to that, we are entirely at your hands, Mr. Chairperson.
Yes.
Mr. Titi, can you just place on record the reasons that you would need, this 2-week extension?
Well, in a sense, as stated in paragraph 8, we are saying the information contained in the allegation made against Anderson, and in particular the transcript, was only received on the 15th of August 2021. Secondly, time is needed to consider the allegation and consult with those involved in dealing with this matter. Thirdly, the associate referred to above left Anderson in on around 2017 and has gone to the bar. We will need to consult with her in order to obtain any information and or recollection she has. And lastly, by the very nature of a law firm, before any decision are taken regarding issues such as this, they need to be discussed with the directors. This will take some time. In addition to this, it may be necessary to take advice on the extent to which Anderson can respond based on whether legal privilege is still applicable. I guess that, the last point is the pending issue here. Once those allegations are made, we need to consider whether the people that have made the allegations still enjoy the legal privilege. And how far can we go in disclosing the nature of the consultation and the information at our disposal when we advise them as to what was the best available legal option for them. So in essence, those are the reasons why we seek an indulgence for extension up until the 6th of September. But I mean, Chairperson, we are at your hands here. If you feel the 6th of September may put a serious time constraint to your commission, we will take guidance from you.
Dr. Could you just lastly from my side, has the firm done any work so far in terms of trying to speed up the process of preparing a response?
Yes, we have identified, as mentioned on the above bulletproof, we have identified the issues where we need to go, basically. There was an associate that was helping Mr. Woodhouse in this matter. We've since gone to the bar. So we have arranged a consultation with her as well, because you will see from the submissions that are going to be made, she was the one who was communicating with Mr. Mbalati in particular, and there will be letters to that effect.
Yeah. Mr. Abram, in response to the application by Mr. Dr. Petty.
Thanks, Chair. I just thought maybe I should just clarify just a few things, Chair, and we have had regard to the reasons Anderson is advancing rather for the application for the extension of time. Dr. Kriti, just a few things. You mentioned that the associate was particularly in contact with Mr. Mbalati. So
yes.
I take it that you have received the final affidavit of Mr. Mbalati by now.
Yeah.
Is there anything, and I believe that you've received a transcript as well, relating to Mr. Mbalati's oral evidence? So, in other words,
I missed the last part.
sorry, I'm saying I was just trying to establish whether you received the relevant transcript as well.
Yes, we have. It's the affidavit and the transcript.
Yeah. So I just want to be sure that you've got everything you need now to be able to formulate your response. Because that gives us a sense as to why you seek an indulgence up to the 6th of September. You know, as
Yes.
the Ombudsman has stated, obviously we operating under very strict time limits and so on. So
Yes.
obviously in my mind as you were speaking, what came to my mind is what informs the date of the 6th of September per se. I mean, you're saying, number one, that the associate has left the firm, and I take it that
Yes.
Mr. Woodward is still there. And
Mr. Woodhouse, yes.
Woodhouse, sorry. And in the scheme of things, Woodhouse is senior to the associate who left. Issues like you considering the privilege issues and so on. And I take it that all those processes are already ongoing. So
Yes.
given that we are sitting on the 23rd of August now, and so that we don't have to delay this any further than the chairperson would make a ruling. So the point I'm trying to make is that I take it that all these processes are happening simultaneously as we speak, or that you have already.
They are right underway. Yes.
Sure. And did you receive any information at all from the CSA? In other words, from SACA rather. So what we do in the scheme of things is that as soon as allegations are made before the Ombudsman, we furnish relevant affidavits and transcripts instantly. So have you received any information from them at all that is of assistance to you?
Yes. The information that is in our position is the one that we have stipulated at paragraph 5.1, 5.2 of our letter, 5.3, 5.4, and 5.5.
Okay. I think that for just audit purposes, I think it would be useful if I take it that information is sufficient for you to formulate your response, other than those other issues. So if there be any, please let us know today still, because we want to make sure that we do not delay the process in any way whatsoever. So we want to make sure that from our side, there are no outstandings at all. So, yeah, thanks for that, Dr. Kwiti. Having said that...
Maybe I should ask from your side, is there any information beside the one that is mentioned at 5.1 to 5.5 that relate to Anderson, that has not been furnished to Anderson?
We believe we've furnished you with all information that's relevant to you.
What information?
So that's why I say that should you find out, maybe in the course of reading these documents, should you find that there's more you need, let us know. So that we can assist you as well in meeting with your deadline. So, having said that, we can only say that we've heard the reasons why you're applying for extension, and you've placed them on record, and we're in the hands of the chairperson. Thank you very much, chairperson.
Okay.
Well, it looks like there is a willingness on both parties to try and make this happen. The date of the 6th of September, I'm told, falls on a Monday. And I suppose, like all lawyers, you want to have the weekend to work on it. Unfortunately, I'm going to give you up until and including the 3rd of September, so that weekend is used by me and those to whom the submission will be made. So in light of everything that has been said by both sides, your application for extension is granted up to the 3rd of September 2021.
We are indebted to you, Chairperson.
Yeah. Thank you very much. I think that that brings to an end this submission, and you are excused, Ms. Dr. Priti. Thank you very much for appearing.
Chairperson.
Yes.
Thank you.
And that is, well, we'll take the lunch hour adjournment at this time. And we'll be back at 1 o'clock.